How does divorce affect your estate plan? Well, if you were a married person and had an estate plan, the divorce itself upends your plan. So you need to figure something out. You need to change things, and you need to see what, if anything, is no longer acceptable. What do I mean by that? Well, let's go with a simple will. If you had a simple will and you were a married person, it is likely that your will said, if I pass away, everything I own goes to my spouse. And if my spouse predeceases me, then the following happens. So after you're divorced, you probably don't want everything going to your spouse. And in fact, even if you subsequently want things to go to your spouse, you have to direct that by a new will written after the judgment of divorce. So I'll back into that story in a second. In your divorce, ultimately, once there's a judgment, there's probably going to be a stipulation that says something along the lines of, for any estate plan, let's take the position that my spouse has predeceased me. So you're probably covered for a will. I wouldn't chance it, because it'll probably get caught in the surrogate's court, and they'll say, hey, show us a marriage certificate or a divorce decree or something. And, whoever or the true beneficiaries can probably prevent an ex-spouse from inheriting. However, that might be for a will, but your beneficiary designations, your life insurance policy, your bank accounts, if you have beneficiary designations, payable on death, in trust for, transfer on death, joint, all of those things will still take place. So after the divorce, you need to revisit your estate plan and then the things that you own. I have a bank account. Let me look at it. Who do I want to be the beneficiary now? I have a life insurance policy. Who do I want to be the beneficiary? I have stocks and bonds, right? And take this calculated look. Look at your financial assets, your belongings. Where are they going pre-divorce, and where do you want them to go post-divorce? Now, I have been contacted by people that divorced 15, 20 years before, and they want their ex-spouse, right, their former wife or husband, to be their executor, to be maybe even a beneficiary. And the reason for that is because they have children in common, and after the pain of the divorce, they've come full circle and become friends again. So you have to reference that they had been a married couple, maybe divorced, not maybe reference that they were married, that they had been divorced, and specifically date things so that there's a full explanation. People just don't think it was a will where the surrogate's court will identify it and say, hey, that person was your ex-spouse. They shouldn't be your executor. They'll give some aggravation to the petitioning attorney. So that's how we handle it. Post-divorce, take a look at your asset classes, where they are, and how you want them to go.